Yeah, there you are.
Super. Thanks very much, Declan. And hi, Lorna. Hi, Emma. Good to get a
Hi,
chance
Paul.
to talk to you again. Again, similar to international, we got a fair bit to cover off, so I'm going straight into it. First of all, in the interest of time, I'm not going to go through any of the MCQ questions now, okay? Because our time will be gone by the time we get anywhere near the last one. So what I will do is I will send on the answers to the MCQ just as soon as we finish this session, okay? If you have any questions on them, you can come back to me. But what I'm going to do is I'm going to focus on the four long questions. First of all, from the mock exam. And then I'm going to put away the mock exam. I'm going to have a look at the real one, and I'm going to give you an indication as to what you might want to focus on for the real exam. Okay, all right. So in the mock exam, we gave you four long questions. You need to do two of them in the real one, and the format is exactly the same. You're going to get four long questions, and you need to answer two of them. So what I'm going to do is give you an idea. If these questions had come up in the real exam, obviously it's going to be different ones, but if they had come up in the real exam, how would we potentially have answered those questions? Okay, what is it we're looking for? Okay.
Yeah.
So the first question in the mock exam is Paddy in Dublin wrote to Mary in Cork offering to sell his Mercedes car for €15,000. On receiving Paddy's offer, Mary telephoned him to say she would like to accept the offer. But because there was such a large sum of money involved, and because there were one or two more interested parties, Paddy said he wanted Mary to confirm her acceptance in writing. He said if he received her acceptance on the next day, which was Friday, he would go ahead with the sale of €15,000. Mary immediately wrote out her acceptance letter and posted it to Paddy in Dublin using standard post. Paddy received it the following morning, which was Friday at 11 a.m. On Thursday evening, however, Paddy had received a better offer from a local guy and he wrote to Mary to withdraw his offer. The letter missed the last collection and was not received by Mary on Friday morning. Okay, so what we're going to do is we're going to discuss that case. So there's essentially two elements to discuss, and you will find that there's two elements in the real exam as well. Okay. The first question is, okay, is there a contract? Okay, and that's anything to do with contract law. The first thing you need to answer is, well, is there a contract? Okay, and then the second thing, which we'll come to in a few minutes, is we'll talk a little bit about the letters going back and forth. Okay, because that applies, and a little bit about kind of the type of offers that we might be talking about either as well, because those are relevant points to discuss on it. And I suppose while it's in my head, I mean, I suppose rest assured, there's not necessarily a right or wrong answer on this. So if you come to the conclusion that a contract was formed, it's and maybe I come to a conclusion the contract was not formed, that doesn't mean that oh well zero in terms of marks. This is law, so the expectation would be that you would try to argue your case, and you can argue it either way. Okay, a good argument either way is going to score as well as as a good argument the other way. Okay.
Yeah.
So let's talk first of all. First of all, has a contract been formed? Okay, so there's four things you need if you're going to have a contract. Okay, the first one is an offer. The second one is acceptance. Third one is consideration, and the fourth one is intention to create legal relations. Okay, so is there an offer? So if we look at the facts of the case, Paddy in Dublin wrote to Mary in Cork offering to sell his Mercedes car for €15,000. Okay, sounds like an offer to me. Okay, now you can talk a little bit about the type of offer. It's not an advertisement. Okay, Paddy didn't put up his an ad somewhere and saying, okay, does anyone want to buy my car? He wrote to Mary and said, do you, Mary, want to buy my car? Okay. So is there an offer there? Pretty good argument for making a case that there is an offer made. Okay. Is there acceptance? So if we keep reading on, it says, on receiving Paddy's offer, Mary telephoned him to say that she would like to accept the offer. Okay, so Mary picks up the phone, rings Paddy, and says, yes, Paddy, I would like to accept the offer. Okay, Paddy then, if we then read the next line, it says, but because there was such a large sum of money involved, and because there were one or two more interested parties, Paddy said to Mary he wanted her to confirm the acceptance in writing. Okay, so he puts a bit of a stipulation on the acceptance. Okay, and he said if he received her acceptance the next day, which was Friday, he would go ahead with the sale at 15,000. Mary immediately sits down, writes the acceptance letter, and posts it to Paddy. So pretty good, pretty good case there for acceptance. Okay. Third thing we need is consideration. Okay, so something needs to change hands. If Paddy just contacts Mary and says, "Would you like my car, Mary? I don't need it anymore." That's not an offer or a contract. It's a gift. Okay. but it's not a gift because there's talk of €15,000 changing hands, and Mary has talked about accepting it at 15,000. So the discussion on consideration comes in. Okay, so is there consideration? There's talk of a car going one direction. There's talk of 15,000 going another direction. Again, pretty good argument for saying there is consideration there. Okay, you don't need to get into whether or not 15,000 is enough for it or not, and that doesn't really matter from the point of view of the courts. If there is something going from one to the other, there is deemed to be consideration. Okay. And then the last question is, okay, is there intention to create legal relations? So is this a discussion that's been taking place at kind of 2 o'clock in the morning over a large number of drinks where maybe both of them are not necessarily in the best state to be making agreements to buy cars? No, doesn't appear to be that case. Paddy is writing to Mary. Mary is writing back to Paddy and supports it with a phone call. Paddy is then talking about withdrawing offers, so he's writing to back to Mary as well. So does it suggest there's intention to create legal relations? You got 2 or 3 letters kind of going there. You got a couple of phone calls. Is there likely to be intention to create legal relations? Yes, there's a good argument there. So what we're looking for you to do is looking for you to first of all tell us what is needed for a contract. So it's offer, acceptance, consideration, and intention to create legal relations. And what we're looking for you to do is, as I've hopefully been doing, is link back to the facts of the case and say, okay, why do I feel there's an offer? Why do I feel there's acceptance? Why do I feel there's consideration? And why do I feel there's intention to create legal relations? And you can also back it up. I mean, if you're looking for high, also back it up by mentioning, okay, there was a case there which reminds me of this case, and this is what happened. There's a case over here that where something different happened, and it reminds me of that case. And that's why I feel there's not only do I feel it's right that there's an offer and acceptance, there is also a legal precedent for showing that this is enough consideration. This is enough for intention to create legal relations. Anything like that you can find in the notes. Okay. So we need to talk a little bit about the postal rule and the letters in a minute, but so I'll just pause there for a minute on the general question of whether a contract has been formed or not. Do you have any questions on it?
No.
Nope, we're good.
Mm-hmm.
Super. Okay, very good. Okay, so the second thing to kind of talk about in this, so that'd be missed not to include, is the letters. Okay, so the letters are kind of going back and forth. Okay, so we have a scenario where Paddy says, so Mary accepts the phone call, accepts the offer, but does it verbally by phone. Paddy says, okay, well, I'd just like to, because we're talking kind of cars and a big portion of money, I'd like it in writing. Mary sits down and immediately posts it. Okay, so the postal rule states, okay, once the letter hits the post box, even if it's deemed to be accepted. Okay, so even if, I don't know, the postman gets sick and that gets missed, that post box gets missed for a day or two. Once the letter accepting hits the post box, that's Mary's job done. That's deemed to be acceptance. Okay, now you can get into a discussion. Okay, well, I mean, I don't know if you'd ever go into CCTV footage for what would essentially be a civil case here. It's not a criminal case; it's a civil case. But you may get into, okay, well, here I can produce some evidence of Mary posting the letter. If she had sent it by certified post, there would be a record of it. That's one of the reasons that people use certified post, because it'll give a date and a time, and somebody independent will confirm it. But you can get into those type of discussions. But essentially, did Mary's acceptance predate Paddy withdrawing the offer? Yes, it probably did. Okay. Now, like I said, you can get into, I mean, what is a good thing to do in a legal case is, well, if this had happened or if this had not happened, this would have been the outcome, or this would have been the likely outcome. But essentially, if you're asking me and saying, okay, well, what do you think? I'd be saying, well, based on the facts here, Mary's letter hit the post box ahead of Paddy sending a withdrawal letter. So therefore, offer is accepted. Paddy should complete the contract. Okay. To kind of go through that, to read the facts, and you're obviously going to be getting a different set of facts, and I'll repeat this at the end. But essentially what we're going to be looking for is, in the contract question, there will be a contract question, different set of facts. We'll be asking you, okay, well, do we have a contract here or don't we? And then the second part of the question will be, okay, if it is deemed to be a contract and one of the parties is looking to enforce that contract, what are the options? Are we talking damages? Are we talking, specific performance of the contract? What would be an appropriate resolution to the impasse? Okay, so that's basically it. I mean, that's the question. The only thing I don't give you is today is the facts of the contract case. So there will be a contract law case. It will ask, is there a contract or not? And there will be okay, if there is deemed to be a contract, what is an appropriate next step to take in terms of resolving the impasse where one party thinks there's a contract and the other does not. Okay. So before we move on to company law, which is question 2, are there any questions on that?
No.
Nope, we're good.
Good.
Yep, super. Okay, so company law question 2, which comes from module 2, which is under company law, is the following. So Murphy Limited has indicated in their company constitution that they will renovate houses and apartments and sell them at a market price. For 5 years, they continue this undertaking, but then, following a review of costs and recent sales across the country, they determined that there is significantly more money to be generated by purchasing land and developing it. Without undertaking any change in the company constitution, they embark on this new venture, borrow a significant amount of money from a loan bank, purchase their first plot of land. Outline possible consequences for this action for Murphy Limited, describe how these limitations have been relaxed over time, and what steps can Murphy Limited take to avoid this problem. Okay? So a three-parter question, okay? The consequences of what's happened, how have the limitations been relaxed a bit over time? So that's a wider kind of question. And then finally, going back to the facts of the case, what steps can Murphy Limited take to avoid the problem? So the first thing that could happen in this circumstances is the transaction may be deemed void, okay? So you could have a scenario where, I mean, the most likely scenario where the transaction might be deemed void would be maybe Murphy Limited do the transaction and then they lose a ton of money on it, okay? Loan bank want their loan repaid, and Murphy Limited are saying, okay, well, maybe there's a way we can get out of this. We should never have been allowed get a loan for this purpose in the first place, okay? So the transaction may be declared void, okay? That's the first thing that could happen. Second thing that could happen is that loan bank may be allowed by the courts to enforce a detrimental contract. I mean, let's say that Murphy Bank loses a lot of money on this transaction. That happens, okay? And perfectly legitimate transactions are, you do have people that lose money all the time. It could be that the court's going to say, well, all right, yeah, you shouldn't have borrowed money for doing that, but you're only trying to wriggle out of it, so we're not going to support that conduct. So we're going to allow the transaction to stand. Okay, so loan bank will still be owed the money. That's the second thing that could happen. Okay, the third thing that could happen is if let's say an interested party, so let's say a shareholder in Murphy Limited, hears about this and says, hang on a sec, these guys are embarking on a completely different type of transaction to the type of business they're supposed to be doing. I think they're going to lose money on it. So, and as a result, I will lose money on it. So an interested party could put forward an injunction to stop them from making the deal. So, at the last minute when the deal is about to go through, somebody might put their hand up and say, hang on a sec, this has come to my attention. They go to the courts and say, if this is allowed to happen, I'm going to lose millions. And the court could potentially put an injunction in place to stop the directors from proceeding with their transaction. So one of those three is probably the most likely outcomes from the set of facts that you've been given. Okay. The second part of the question is, how have things relaxed over the years? So in 2014, there was a Companies Act that was published, okay? And the Companies Act previously the Companies Act is going to say, okay, you need to have as part of your articles of association, you need to have an objects clause. Okay, you said the object of this company is to make money, and this is how we're going to make money. So you may list off the business affairs that used to be, and that's the way it used to be. Okay, things were relaxed a little bit over 10 years ago, where part of the powers of a company could include to embark on any venture that the directors think will make money for the company. It could also say the directors are entitled to borrow money for any venture that they think may be beneficial to the company. So it loosened the restrictions widely. So it used to be that if the company said, okay, we'll be doing business in one of these four areas. if somebody identified a fifth area and said, here, you've drifted all off into this fifth area, the company could be blocked from embarking on it, or any transactions that happened might be deemed null and void. But a little bit over 10 years ago, the requirements were relaxed in the 2014 Companies Act. So companies can now embark on things that they feel will make money, and they're not necessarily tied to the four things that they said in their constitution could happen. So, and then the final part of the question is, okay, well, what are the possible kind of defenses? I mean, what could Murphy Bank do to try to kind of to try to reduce the impact of this? So the first thing is they could try and show that the directors were indeed empowered to change the direction of the company. So they might point to a clause in their company constitution that says, okay, directors can do anything that they think is going to be beneficial to the company. Here it is, there in black and white in the constitution. So we're allowed to do what it is we said we'd do. The second thing you could do is maybe they don't point to such a clause, but they could say, well, no, it was a completely different area of business. That's true. It's not captured in our company constitution. That's also true. But we told Loan Bank this, and here's emails or minutes from meetings. Here's evidence that Loan Bank knew that this is what we are going to be doing, and that it wasn't actually covered in our constitution. So they can show that Loan Bank did it. So did know about this, and as a result, there's no reason for the transaction not to proceed. Okay, and then the last thing you could do, which is probably a bit of a left field one, is you could in theory show that the behavior was not legal in the first place. So if they were embarking on some sort of venture that was completely illegal and that they had no right to do, and that no company would be entitled to do, that could potentially be reason for the court to set aside and say, right, everybody go back to the way you were. And Loan Bank get their money back. Murphy Limited, forget about their plans, and everybody goes back to the way it is. So difficult one to prove, but a possibility. Okay. So there's a lot of information in that. There's three parts to the question. The real exam, the question is a little bit more straightforward. But that is how we would be looking. That's the type of material we'd be looking for if exactly the same question came up in the real exam. So that's on company law. Any questions on that?
No.
Okay. All information available in module 2. Okay.
Yeah.
So question 3 relates to module 3 and relates to EU law. Okay. So shorter question on this one. So you've just got a couple of little bit of quick facts at the beginning, and then you're free to go and discuss it. The Commission wants to cut greenhouse gas emissions across the EU. Okay. They settle on a figure of a 33% reduction over a 10-year period. Describe how this proposal would progress through the EU institutions to become binding on the member states. So this information is in module 3. Okay. So the first step is the consultative stage. Okay. So the Commission drives the strategic direction of the European Union. So they are the first player involved in this process. So they will have come up with this idea and say, right, this is what we want to do. And they will start by submitting proposals to the Council of Ministers and the European Parliament for consideration. So they're saying, this is the direction we want to go in. Have a look at these. Okay. The Commission will take the interests of individual member states into account. So for argument's sake, let's say that a 33% cut in greenhouse gases would impact farmers more than anybody else. And let's say that Ireland and France are the two countries in the EU with the most farmers and are most heavily reliant on the agricultural industry. They would take that into account, and they would say, the options that they may have might be, okay, well, maybe we give those countries a little bit longer to implement it. Maybe we allow for a lower reduction in emissions, something like that. Now, keeping in mind the European Union, as the name suggests, would be kind of, it applies to one, it applies to all type thing. That the likelihood of that happening is maybe a bit lower, but they will be taking the individual. They probably won't kind of say you have longer or you can reduce it, but they may provide additional financial supports. They may be a bit more flexible as to how the countries go about it. So those are things that the Commission would discuss with individual member countries. They would have discussions with individual member groups. So what they would do is they would say, okay, well, who's likely to be impacted by a reduction in emissions? Would it be farmers? Would it be maybe the motoring industry, because maybe we want to have less cars on the road and more bikes? Would it be energy groups, because energy groups provide electricity? Okay. Maybe we want to, by reducing emissions, they may have to find alternative source of energy. So maybe we need to engage with them. Farmers, we mentioned them, and maybe business groups. Okay, so maybe business groups are emitting an awful lot of emissions as they go about their business. Maybe those are the ones impacted. So the commission would sit down and talk to representatives of each of those groups. They would discuss the potential negative impact of what is essentially a positive move to reduce global emissions. But they would also talk about, okay, well, how could potentially these business groups be supported to allow them to go ahead and make the changes that they need to do? Maybe there'd be money made available, for instance, to allow them to do it. Okay. So that's step one. That's the consultative stage. Step two is the review stage. Okay, so once the proposal has been finalized, it is sent to the European Parliament and the Council of Ministers to review the proposal. Okay, similar to the Dáil committees reviewing a proposal from a relevant minister, which is covered in the notes in Module 1. So if the Council and the Parliament can't agree on whatever wording or whatever exact amendments are going to take place, a second reading of the proposal takes place. If at the second reading these groups still can't agree, further amendments with the Parliament may be discussed. If both institutions can agree on the amendments, then the proposed legislation can move forward. If they are at an impasse, then a conciliation committee comprising of members of the Council of Ministers and also members of the Parliament is formed to try to work through the deadlock. Okay, but both the Council of Ministers and the Parliament can, in theory, still block the legislation from going through. And then the final stage of the three stages is the adoption stage. Okay, so Council of Ministers, Parliament, and Commission have all reached agreement on the wording of the proposal. Parliamentary committee votes on it and possibly amends it. Then it is voted on by the Parliament, and once it is approved by the Parliament, it is deemed to be adopted. Okay, so those are the three stages that such a change would go through in the European Union if such a change was to take place. Again, a more straightforward one coming up in the exam, but that is how you would answer question 3 if the real one came up in the exam, which it won't. Any questions on that?
No.
No, we're good. Okay, lovely. How are we doing for time? We are doing well for time, actually, for once. So we're good. Okay, so final long question, which is tort. Okay. So the first thing I'll say on the tort question, there's actually 4 parts to this question. Some of them some of them you could use the same information to answer part A and part C, or maybe part B and part D, but there is only 2 in the real one. So we have shortened it a little bit. But the facts of the tort case are as follows. Declan is a young teenager who is being bullied by another young boy, Rod, in his class at school. Rod has been taking Declan's lunch money and threatening to beat him up if he tells anybody. For months now, Rod has been making Declan's life a living hell. Walking home from school one day, Declan notices a local farmer, Tom Brown, has left the gates to his field open, and being naturally curious, he wanders in. The field contains a large barn, and it too is unlocked, so Declan wanders in there to have a bit of a nose around. He searches through some presses and finds a shotgun. The farmer has a license for the shotgun and is a member of the local gamekeeping community, a fact that is well known in the community. The gun is empty, but upon a more thorough search of the barn, Declan finds some shells. He hides the gun and the shells in a school bag and heads for home. The following day, Declan arrives at school, sees Rod playing in the yard, takes out the shotgun, which has already been loaded, turns it on Rod and shoots him, causing serious injury. Declan himself also suffers an injury because of the kickback from the shotgun. Rod's parents want to bring a negligent action against Tom Brown because they believe that any person who owns a gun should be legally responsible for injuries caused for that gun. Okay? So there's then 4 questions that follow, okay? But the first one, not too surprisingly, is to bring a successful negligence action, what would Rod's parents be required to prove? Okay, so there's 4 requirements to prove that a contract exists in contract law. There are also 4 requirements to prove that a negligence action has taken place under the law of tort. So what is yes.
Oh, sorry, I need to leave. Sorry, Emma.
Oh, yes.
I have to go for an appointment.
Sorry, yes, Lorna. Yeah, you told us that. Yeah.
Yeah.
The replay will be available, so you can follow question 4 in the replay. Okay.
That's lovely. Thanks so much.
Okay. Best of luck, Lorna. Take care.
See you soon. Thanks a million.
So Emma, you now get 1-to-1 tutoring. Okay. So I'll keep going. So four things to prove in negligence, okay? Duty of care is the first one. Breach of the duty of care is the second one. Damage. And then a link between the damage and the breach of duty. Okay, so those are the four things required to prove a successful negligence action. Okay, so similar to contract, what we'd be looking for you to do is go through each of those and try and discuss using the facts of the case whether or not you believe a duty of care, a breach of duty, damage, and a link between the two actually exists. If all four of them are there, pretty good case for negligence. If one or more of those are missing, the case for negligence is a lot weaker and may not be there at all. Okay. So if we just quickly go through those, is there a duty of care? Okay. We're talking about guns. Okay. So, guns are by their nature very dangerous. There may be plenty of other products out there which by their nature are not dangerous. So is there as high a duty of care to mind those and have them locked away? Probably not. But a gun is particularly dangerous. So is there a high duty of care that comes to anyone who has a gun? Yes, probably a good argument to be made there. Was there a breach of that duty? Okay, so the gun, where was the gun found? The gun was found in a barn. Okay, now under criminal law, which could come into this as well, but under criminal law, there would be requirements for anyone who has a gun to have it locked in a gun safe. I just know this from personal experience. The gun safe needs to be kind of stuck to the kind of ground and so on. It can't be lifted. So there are requirements as to where you store a gun. Okay, a barn is probably not the right place to be storing it. So is there a breach of duty? There could certainly be a strong argument for it. Is there damage? This side of the four is probably the easiest because Rod has been shot and Declan has also sustained some injuries from the kickback of the gun. Is there a pretty good argument there for damage? Yes, there is. Okay, there's two examples. Okay. And then the last thing, is there a link between the two? Yes, there probably is a strong one. I mean, had Declan not found the gun, would Rod have received it, been impacted by the damage? No, he probably wouldn't have been. Would Declan have experienced the kickback? No, he probably wouldn't have been. Can you just bear me 1 second? I just need to talk to a kid for a moment. Just bear me 1 second. Okay, sorry about that. So is there a link between the two? Yeah, pretty good link. If Declan had not found the gun, would damage have been caused to himself or to Rod? Probably not. Have we kind of certainly established a strong-ish argument for there being a duty of care and a breach of that duty? Yeah, there probably is. Now we get into more specifics in the next questions, but at a high level, there's probably a good argument for there being a negligence case. Emma, any questions on that? Nope, you're good.
No,
Okay.
that's all good. Thanks.
Nope, very good. Okay, super. So question 2, will Tom Brown have the defense of contributing negligence because Rod bullied Declan? Interesting question. The short answer is probably not. A couple of facts to keep in mind, okay? Rod is a minor, okay? And so he's been bullying Declan. Not pleasant, not nice, but something that does happen, okay? In schools. Unfortunately, probably happens in most schools, probably every single day, okay? Not nice, but does happen, okay? Is it often that you have a scenario that somebody comes to school with a gun in this country and shoots them? No, very, very rare, okay? Thankfully. Okay, so is there likely to be, would Rod at any point when he was bullying Declan have kind of said, you know what, there's possibility here I could get shot? Probably not. Okay, very, very, very unlikely. So the likelihood, particularly because Rod's a minor, the likelihood of Tom Brown being able to rely on contributing negligence and saying, well, Rod brought it on himself and should have known that he'd ultimately get shot because of this, very unlikely. Okay. Point C. Rod's parents believe that Tom Brown was negligent because he left the gates open, left the shotgun in an unlocked barn, and because Declan was able to find the shells in the barn. For each of these allegations, determine is there an actual causation. So let's just take those in turn, okay? he left the gates open. Okay. In the country, is it common that gates to a field be left open? Short answer would probably be yes. Okay. I do live in Dublin, so I'm not an expert. But are gates regularly from my visits to the country? Have I seen gates open and unlocked? Yes, regularly. Okay. Pretty good chance that it's a little bit tough to rely on the fact that there's definitely negligence because Tom Brown left his gates open. Now, the test that you would probably want to apply in this case, were this in court, is the reasonable person test. Okay, is it reasonable to leave gates open in the country? Short answer, in my opinion, probably yes, but you could argue a different one. Okay, but the reasonable person test, is it reasonable to leave a gate open in the country to a field? Lots of people ramble through fields, open and close gates all the time. Countries, probably not unreasonable to do it. Okay. You then have an unlocked barn. Okay. My knowledge of barns is even worse than my knowledge of gates. So is it reasonable to have an unlocked barn? Barn, by their nature, I would say, are maybe not the safest of places for kids to be around. Okay, even if there's no guns in the barns, which I think in general there probably aren't. You may have hay bales or things like that. You may have agricultural machinery, all sorts of things that potentially are dangerous for kids. So you could then make an argument either way. Okay, is it reasonable or unreasonable for a barn to be locked or unlocked? You might say, well, if the barn is miles away from the road and nobody can get to it without trespassing it, he may have a right to kind of keep his barn unlocked if he wishes. If the barn is very close to it and the gate is unlocked, were it not for the unlocked gate and the unlocked barn, would Declan have gotten hold of the gun? The answer is probably no. Those are the type of discussions that you'd want to lay out as part of your answer. And then finally, Declan was able to find the shells in the barn. Is it reasonable to have a gun in, I suppose, just a press? Doesn't sound like it was in the gun safe. Is it reasonable to have the bullets maybe nearby? Probably not. Okay. Could more have been done? Almost certainly yes. Okay. So the open gate, probably not much. I'd probably be siding with Tom Brown on that one. The unlocked barn might depend. But again, even with no guns in a barn, I don't think barns are maybe the safest of places. The judges might rule the same way. There are when we talk about specifically the guns and the bullets, is it should that be left in a barn that is unlocked? Probably not. So as the argument goes on, it probably gets stronger and stronger in favor of the plaintiff and weaker on Tom Brown's side. Okay. And then lastly, the final question, can Declan maintain a cause of action for Tom for his injury? Short answer is probably yes, because he's a minor. Okay. If he's not a minor, probably not. That's where things like contributing negligence could come into it. So, well, Declan, you got hold of the gun. You're the one that pulled the trigger. If Declan were a grown up, there'd be a strong case there for kind of contributing negligence. So Tom Brown might well find himself in trouble in relation to Rod, but whether or not Declan would succeed if he sues Tom Brown, he probably wouldn't if he was an adult. But because he's a minor, pretty good case. So minors do things that maybe they regret in later life. Pretty good case that Declan himself, despite the fact that he fired the shots, could well have a case there as well. Okay. So that's a bit more detail than we might maybe be looking for in the real one. In the real one, there's only 2 bits, okay? And I will go through this again in a minute, but in the real one, what are we looking for? We are looking for question, is there negligence? And we're also asking for, well, are there defenses? If you're the defendant in the case, are there potentially mitigating factors or things you could argue that might either get you out of trouble altogether or reduce the damages that you might have to pay? I mean, that's essentially the question that we're going to be asking. The only bit that I don't share with you today is the actual facts of the case. Okay. So before I go on to the real exam, any questions there, Emma?
No, that's all really clear.
No, we're
Yeah.
good.
Yeah.
Super. Okay. So just to recap, I mean, I've covered a lot of this already, but to recap for the exam, so there will be the multiple choice tests questions. Okay. That is 50 questions, if I remember correctly, and they will be worth 40 marks. Okay, and you'll have an hour to complete that. Okay, so similar questions. Some of them may even be exactly the same as they are in the mock test. The only word of warning I will say is, it's not impossible. We may have changed them around a little bit. So, the right answer in the mock one could be the wrong answer in the real one. So the word not might appear in one but not the other, things like that. So just be very careful, read the question carefully. And if you see it and it looks similar to one in the mock, don't assume it's necessarily the same one. So just be careful. But most people score pretty well on the MCQs, okay? Not sure anyone's ever gotten the whole lot of them right, but 48, 49 out of 50, 47, I've seen those scores, okay? So that's the first hour. The second hour is the longer questions, okay? Similar to the real one, you're going to get 4 questions, which I'm going to go through now in a minute. You need to do 2 of them, okay? So those multiple choice questions are worth 40 marks. Each of the longer questions is worth 30 marks, so that brings you to a total of 100. We're then going to convert that into a score out of 70. So if, for example, you got 50%, we're going to award you 35 marks out of 70. We're then going to add up to 10 marks for assignment 1. We're going to add maybe up to another 10 marks for assignment 2. And then we will add up to 10 more marks for the average result that you got in the 4 short tests to give you your total final result. Okay. So on the long question, so it's 4 questions. First one, not surprisingly, is contract. So like I said earlier, it's going to be a different set of facts, but it's essentially the same question. Do we have a contract? Okay. And if we do have, the second part of the question will be, if we do have a contract, how would we compensate the injured party? Okay. Damages, specific performance, injunctions, rare but possible. What is it we would look to do? What's the next step? What should the court realistically say in relation to the fact, okay, we now agree there is a contract. How do we sort this out? Okay. So contract law, different facts. It's not Paddy and Mary and the Mercedes. It's different facts on this one. But similar question. Is there a contract? And what are the remedies for the injured party if we decide there is a contract? Question 2 comes from company law. And I'm going to be very nice here. I'm going to be very specific. It's on the Consumer Credit Act. Okay, so that's a small portion of module 2. It is on the Consumer Credit Act. Okay, you're going to be getting a set of facts. And you're going to say, okay, what needs to happen in this case? Okay, so it's the Consumer Credit Act, which is not that long. If you read that and know it well, you'll be well positioned to answer question 2 if that's the one you choose to do so. Okay. Question 3 comes from module 3, which is primarily on EU law, and this will be on EU law. And it's from the early part of the EU law section, okay? So first few, 3, 4, 5 pages will give you enough to answer that particular question. Now, again, sorry, I said this to the international group, but you may have heard it or may not. It's not a scavenger hunt, okay? So it's not a case of, here's the right module. There's the 4 or 5 pages. There you go, Paul. There's your answer, and we get our own notes back. We know what's in the notes, okay? So we're looking for things in your own words, in your own explanation, okay? But module 3 is from EU law. Sorry, question 3 is from EU law, module 3, and it's from the early part of EU law, okay? And then finally, question 4, not too surprisingly, is about tort, okay? So again, it's not going to be Declan and Rod and Tom Brown and the gun. It's going to be something different, okay? So different set of facts, completely different set of facts. But again, similar questions, okay? So part 1 is, well, is there negligence or not? So you need to talk about duty of care, lack of breach of the duty of care, damage, and connection between the two. And then the second part is, well, what defenses? The defendant is banged to rights, there is negligence. What can the defendant do to maybe reduce the damages or get themselves out altogether? The first place you would probably be looking there would be contributory negligence. Okay. And that's it really. I mean, just on the contract and the tort, go through the kind of, is there what we need for a contract, or is there what we need for negligence? Go through those, link them back to the facts, keep going back to the facts of the case and saying, okay, because of this. The one bit of guidance I'll give that I maybe haven't given so far is, go in a logical direction, okay? Every now and again, I see a student that kind of says, yes, there is an offer, there is acceptance, there is consideration, there's intention, legal relations, and therefore I believe there is no contract. And I said, sorry, what? Where did the no contract bit come from? So no contract is fine. No negligence, absolutely fine. No problem there. But back it up, okay? This is why there is no contract. This is why there is no negligence, okay? So don't go down one route. Every now and again, I've seen that more than once. People have kind of said they've been going a direction, and I said, right, and I'm all set to award them a load of marks. And then I see, hang on, based on that, there's no contract. because so and so should have done, and they come out as something completely out of left field, and they don't even develop it and talk about it. So, and that reduces their score quite a bit because there's no real logic in what they've ended up concluding. So there should be a conclusion. But you're welcome to argue on either side. Okay.
Brilliant.
That's
Okie doke.
great. Well done, Paul. And a minute spare. Okay, well, look, I stopped the recording now.